A while ago, I created and uploaded a 6-hour-long documentary video where I established how bad the corruption was in the United States. I also offered a solution to this problem, using the power of voter initiative to pass reform legislation without the state legislatures getting a say in the matter. However, in order to sell you on the idea of passing such drastic legislation, I had to spend nearly 3¾ hours driving home just how rampant the corruption was. During section 2-2 of that video, I addressed the issue of judicial immunity. I cited a Supreme Court case called Pierson versus Ray, which argued why judicial immunity needed to exist. In the excerpt that I showed you, they argued that a judge's erroneous rulings can be corrected on appeal. No doubt, this argument was made as a means of assuring concerned citizens that judges would not be entirely above the law because of this immunity. Those of you who have watched the entire video, well, first of all, I commend you for your patience and attentiveness to be able to sit through the entire 6-hour-long documentary. Second, you will also know that I scoffed at appeal as an adequate remedy. However, my actual argument that appeal is an inadequate remedy mostly boiled down to, because if somebody bribed the trial judge to rule in their favor, what makes you think they aren't going to simply bribe the appellate court to affirm their judgment and protect their investment? Seriously, come on, people. This is, admittedly, embarrassing on my part. I am, for the most part, proud of my work in that video. I take great pride in the amount of research I did, and the way I backed up my statements with hard statistics and facts, which were verified by over 100 different sources. This particular argument, however, sticks out like a sore thumb in that video, because it is one of the few statements I made where my only real evidence to support it was appealing to common sense. If there is one thing I have learned in my years of dealing with corrupt government, it is that something is not necessarily true simply because it agrees with your quote-unquote common sense. After all, that entire 6-hour video was dedicated to squashing the general misconception that, in the rare event someone is caught being corrupt, we can at least take solace in knowing that they will get their just rewards if they are caught. That is one of the few comforts that allows people to sleep at night, but in reality, nothing could be further from the truth. Fortunately, I never stop looking for evidence of corruption, anywhere I can find it. Well, lo and behold, I actually found some evidence that appeal is an inadequate remedy. Ladies and gentlemen, I present to you the website of the law offices of Goldstein and Russel, PC. Namesake partner and attorney Thomas Goldstein is one of the most experienced Supreme Court attorneys in the nation. He is also one of the most active, claiming to be counsel of record in 1 out of every 10 Supreme Court cases for the past 15 years. More importantly, he is a co-founder and publisher of SCOTUS blog, supposedly the only weblog to receive a Peabody Award. It is safe to assume that this guy knows the Supreme Court. when it comes to the Supreme Court, this guy knows his shit. Well, his website also has a page dedicated to explaining, in layman's terms, what criteria the Supreme Court looks for when deciding which cases to hear. See, we've all heard the statistic a million times before that the Supreme Court hears less than 1% of the cases that are presented to them. That much is common knowledge. For the most part, the majority of us accept this as a necessary evil. The Supreme Court simply can't hear every case brought to them. Cases simply come onto their desk far, far faster than they could ever be capable of hearing them. After all, unlike the federal appellate courts and state Supreme Courts, the U.S. Supreme Court has to hear cases from all over the nation. Also, federal appellate courts have the advantage of assigning only 3 judges to hear a case initially, whereas the U.S. Supreme Court must have all 9 justices hearing every case, because to do otherwise would effectively create multiple Supreme Courts, and the Constitution requires that there can be only one Supreme Court. So, for the most part, this is a necessary evil. The question then is, what criteria does the Supreme Court look for when deciding which cases to hear? Obviously, it must restrict its cases to only the most extraordinary cases where there are the biggest constitutional ramifications. But what exactly makes a case extraordinary or the constitutional ramifications big? Frankly, according to the website of Goldstein and Russel, the factors the Supreme Court considers are in fact the last factors on the planet the majority of us would expect them to consider. They look for a circuit split, aka a question of law where the federal courts are divided. That's it. That's literally it. That's the only factor that substantially increases the likelihood of getting your case heard by the Supreme Court. You've been arrested for criticizing a judge in an online blog post? Well, your First Amendment right to criticize him is clearly established, so the Supreme Court is likely to not hear your case and overturn this blatantly unconstitutional imprisonment. A judge ruled against you because of a blatant bribe, and even openly admits that he's doing it pursuant to a bribe? Tough! The Supreme Court doesn't take cases where the law is clearly established, so this judgment against you stays on the books. Think I'm exaggerating? Well, the website for Goldstein and Russel clearly shows that I am not exaggerating. The Supreme Court almost never hears cases to review whether a court properly applied settled law or whether the lower court was biased or badly mistaken in interpreting the law. While it may be inevitable that the Supreme Court would have to decide not to hear some cases, I think 99% of us can agree that they should hear cases that are especially egregious and that demonstrate the most egregious abuses of power from government. That's what the system of checks and balances is supposed to be all about, right? However, the current system by which the Supreme Court decides which cases to hear has the net result of the complete opposite. If you're aggrieved by a judge's ruling, you're more likely to get your day in court with the Supreme Court if the judge had an arguable basis for issuing the ruling he did. If other courts have ruled in the same way as him, thereby giving him an arguable basis for his decision, you're more likely to get that decision overturned than if the judge acted entirely out of line and purely for personal gain and/or spite. Now, what does this have to do with judicial immunity? After all, that's how I introduced this video. Well, the answer is simple. Remember that in the case of Pierson versus Ray, the Supreme Court argued that this nation can afford to have judicial immunity because, quote, his errors may be corrected on appeal. By the Supreme Court's own admission, this is the only thing keeping judicial immunity, the absolute immunity from civil suit, from enabling the judiciary to become totalitarian tyrants who casually violate the people's most basic human rights whenever they want to. The ability to have illegal decisions reversed on appeal is, by the Supreme Court's own admission, the only thing that justifies this draconian law, and here we have evidence that the Supreme Court never uses their power of appellate review for any such incident where a judge has acted in a corrupt or blatantly unconstitutional manner. It's the exact same problem we have with the JCOs and their not enforcing the law. They argue that holding judges liable does more damage than good. Well, even if I had even a little sympathy for that argument, which I don't, that sympathy quickly goes away when the courts have an alternative system in place for remedying judicial corruption, and then they just choose never to use it. Of course, there is a way out of this nightmare. As I stated at the end of the 6-hour-long documentary video, we can reform the government, whether the government likes it or not, if we use the voter initiative to pass new accountability legislation. But that will require you to put the pizza down, pick your butts up, and go out and be citizens for about 1 hour a week. So please go and do that.